Illinois' assault weapons ban will remain in place for now after the Supreme Court declined to hear a challenge to the law. The Illinois law prohibits the sale of some semi-automatic assault weapons and high-capacity magazines. It was passed after the deadly mass shooting at Highland Park's 4th of July parade. Opponents challenged the ban, claiming that it violates their Second Amendment rights. Last November, the Court of Appeals ruled the Second Amendment does not apply to those firearms or accessories.
Supreme Court will not hear the Illinois assault weapons ban case, but it's not that bad. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for your NRA certification of multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel-like content and what I do here, you can support me with a link. Everything's appreciated. Connecticut residents, make sure your training is tight for your application for your pistol permit. The new training addendum is in effect. If you have your permit, watch the expiration date. Don't let it expire. Link to the online renewal portal for the state of Connecticut for permits in the description box. Keep an eye on that. Let's talk about this. And this, of course, is breaking news. 2 days old. Well, 3 now. But the Supreme Court is not going to hear the challenge to the Illinois assault weapons ban. Now, when I say it like that, it sounds bad. It's not. What the Supreme Court is not going to hear is a preliminary injunction to prevent enforcement of the ban until the actual lawsuit makes its way through the court. That's what the Supreme Court is not going to hear, which means that Illinois can now enforce or continue to enforce its assault weapons ban. But it doesn't mean that it's over. It's not even close. But what's interesting, Thomas and Alito both had opinions. Now, Alito came right out and said, I would have liked to have heard this challenge. Thomas came out and came off a little bit stronger in his wording, saying that if the state of Illinois can just do this, arbitrarily ban items based on technically appearance, I'm just paraphrasing, that's exactly what he said. I'm going to get to what he actually said here in a second. Then unfortunately, it will open a floodgate, and it's very true. Now, of course, you've got the anti-gun side who are salivating over this. And of course, the people who brought the challenge are saying it's not over. But this only focuses on the preliminary injunction to prevent enforcement of the law, not the actual focus, which would be, is Illinois' assault weapons ban unconstitutional? That's a completely separate thing. Okay? I just want to make that clear because a lot of people are saying, oh my God, They won't hear the assault weapons ban. No, they're wording it to make it sound like that, but that's not what is happening here. But let me bring you into here. Battle over Illinois' assault weapons ban will continue after Supreme Court declines to get involved. Group challenging the law made their bid to the U.S. Supreme Court after last fall's ruling from the 7th Circuit, actually. Federal Appeal Court in Chicago. What did they expect coming out of the Chicago court? It's liberal leftist judges. What do you think they were going to get? But which found that weapons covered by Illinois' assault weapons ban don't have Second Amendment protection, which is pathetic wording in of itself. That's like saying that First Amendment doesn't apply to social media. Me talking to you right now, I don't have the right to speak as freely as I do because the technology that I'm using isn't covered by the First Amendment. It's absolute nonsense. The U.S. Supreme Court would not consider challenges to Illinois' controversial assault weapons ban for now because the case is still alive. That doesn't mean it's not heading to the nation's higher court one day. In fact, a federal judge in Southern Illinois has been preparing for a September 16th trial in which he would more fully take on the question of whether the weapons ban passes constitutional muster. Whatever that trial's result, it could put Illinois' law back on track to the Supreme Court, which Justice Clarence Thomas says must offer more guidance on which weapons the Second Amendment covers. It covers all weapons. Second Amendment. That's why they said arms. Okay, I'm going to come down to here. The Supreme Court's order noted that Samuel Alito would have heard the case and included a 3-page statement from Thomas, who noted that the matter landed before the justice only in the form of a preliminary injunction challenge. Keep that in mind. Now, If the federal appeals court in Chicago ultimately allows Illinois to ban America's most common civilian rifle, which he goes on to claim, which literally defines common use, we can and should review that decision once the case reaches final judgment, Thomas wrote. Yes, but here it is gaslighting. Advocates for the law still celebrated the latest victory, keeping the law in the books. Alice Goh, press secretary for Governor J.B. Pritzker, said it was the results of hundreds of hours of deliberation between legal experts, legislators, and advocates. I'd love to meet these people. I'd love to be a fly on the wall in that whole thing. Because you know how it went. It was, let's just ban these things. Let's just use the incident at Highland Park. And now we can use it. Just like they used Sandy Hook. We can use it. And we can go ahead and get an assault weapons ban. And not one of them even came up and said, well, don't we look a bit hypocritical? Why are we passing this ban for Highland Park when what's been going on in Chicago for decades? Now, because of what happened at Highland Park, what are we saying to the people? What are we saying? When a bunch of white people get killed, we have to take action when assault weapons ban? But the inner city? Just saying. State Rep Bob Morgan, a Deerfield Democrat and chief sponsor of the law, wrote on X that the Supreme Court decision will help save countless lives. He acknowledged that more federal trials remain and our fight continues. Now, the Supreme Court's decision will save countless lives, okay? But just realize, just over the July 4th weekend, we had 11 people killed and 55 shot over, 2-3 day period, okay? This is saving countless lives, but hey, it's in the inner city, so I could go there, but I'm just going to keep it PG so I don't get age restricted. But the 7th U.S. Circuit Court of Appeals in Chicago, that court ruled that weapons covered by the assault weapons ban don't have Second Amendment protection. Rather, it said, such weapons and high-capacity magazines are much more like machine guns and military-grade weaponry than they are like the many different types of firearms that are used for individual self-defense. And once again, it's ignoring, let's just go back to the LA riots and the Korean grocers. What did they do? They took these so-called military-grade weaponry and high-capacity magazines and defended their property and themselves. So it's a bunch of crap. The appellate court cautioned that it did not set out to rule definitively on the constitutionality of the act, though its opinion stemmed from lower court rulings on requests from preliminary injunctions against the law. The 7th Circuit oversees Illinois, Indiana, and Wisconsin. It's out of Chicago. As I pointed out, it's a leftist-leaning district, the court. But Thomas noted the preliminary posture of the case Tuesday, while otherwise criticizing the appellate court's ruling. He complained that its contrived non-militaristic limitations on the arms protected by the Second Amendment seems unmoored from both text and history. Exactly. When the Second Amendment was written and ratified, the musket was a weapon of war and everybody owned a musket. Everybody. And added that even on its own terms, the 7th Circuit's application of the definition is nonsensical. Okay, so I'm going to go ahead and come out of that. So don't freak out, okay? Because this was literally the Supreme Court just chose not to hear of the preliminary injunction, which then, of course, goes back to the lower court of the 7th Circuit, which means that the state of Illinois can continue to enforce its assault weapons ban. It doesn't mean that it's over. But these people on the anti-gun side all taking a victory lap over this is premature and pathetic. Okay, this is nothing as far as I'm concerned. It'd be nice if the Supreme Court heard it and said, yeah, we're going to grant the preliminary injunction or writ of certiorari, but them not hearing it also opens up the gate for the case to move up further, because if they actually heard that case, it could end up becoming basically a system of interlocutory appeal where it could hold up the actual constitutional lawsuit, the one that says Illinois' assault weapons ban violates the Constitution. It could hold it up. So the Supreme Court pushing this aside could be a plus, in my opinion. But in the end, when it gets to the Supreme Court, praying that we keep the conservative majority who actually follow the Constitution and not their feelings, as you heard Sotomayor say when they were actually just made a ruling on presidential immunity. She's like literally boohoo, whining and crying because she didn't get her way, which most of the liberals did, the modern day liberals. But sooner or later, one of these is going to get to the Supreme Court, and we're going to get a definitive ruling on whether or not it's constitutional to have an assault weapons ban. And the faster we get it there, the better it's going to be for us. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'm going to see you on the next one. Peace.